Hey, good morning, everybody. I see Luttrell and In the Cloud are at it right away. We haven't even logged on and the good mornings are coming in. So it's Luttrell by a hair, nudging out In the Cloud by something less than a minute. In the Cloud, the early bird catches the worm. And Donald Trump. What up last night? We're cruising along the highway, going nowhere in particular. And all of a sudden, the New York Post reports that Donald says he's going to be indicted. And it's been confirmed by lawyers close to him. And obviously, that's all everyone's talking about today. And it's likely to be all we'll talk about today. But first, a diversion. Aren't you glad in times like these that there are alternative sources of media and news? And aren't you glad that Elon Musk purchased Twitter? Mike was on a riff last night on Elon and Twitter and the new digital era, and suggests a new reading of Machiavelli's Prince with Elon in mind. And so we got what to refer to it. Well, it was obvious to me that this should be known as the digitocracy. Mike referred digarchy or something like that. And I said, well, let's submit it to a vote. So we put it up to a vote on Twitter. And at last count, I think there was a modest level of support for digitocracy. I think the vote is like 93% to 7% in favor of digitocracy. I realize that all the North Carolina votes haven't been counted yet. And until the polls close at the end of the day, we won't know. But right now, it's digitocracy.
I'm going to put this up on the screen so we can make fun of how crazy my digarchy is getting slammed right now. It's like, I guess this is like the Miami Heat Denver Nuggets final series. So, you got digitocracy down here with Jokic on the team, and then digarchy just getting smashed.
Something like that. But in any case, we'll see whether Elon provides and his Twitter feed a necessary counterweight in the coverage of the Trump crisis. And that's how I refer to it. I'm not sure what to make of this. I mean, the charges as described in the press are a violation of the Espionage Act, that is, retaining these papers that could be of use to a foreign adversary, obstruction of an official proceeding. I believe that's an 18 United States Code 1512 proceeding, which means that there was some sort of official proceeding, aka an investigation going on, and Trump hindered it or obstructed it with some conduct on his own. Lying to federal investigators, which is always going to get you in trouble. Ask Martha Stewart. She did a little time preparing her prison cookbook after lying to investigators about some insider trading charges, and conspiring with others to frustrate federal purposes. It may be in this case that Trump's reaction to the initial conduct is far worse than the conduct itself. I'm aware that Joe Biden had allegedly classified documents in a car in his garage. We have a problem of overclassification of documents, such that virtually everything gets classified at this point. Now, if under the National Secrets Act, you're not supposed to take these things with you, Trump did. They asked for him back, and he either lied or obstructed their investigations about that. Those are serious substantive counts. But really, this is the very week, I think maybe it was last week, that Christopher Wray of the FBI was being considered to be held in contempt because he wouldn't turn over documents to Congress in the FBI's possession relating to a confidential source who has information about Joe Biden receiving a $5 million bribe while he was vice president of the United States. So let me see if I get this right. Let me see if I can understand a neutral application of the law. There's a congressional hearing going on. Yeah, that's an official proceeding. Well, I don't know what else to call it other than a shit show. But yeah, that might make the definition of an official proceeding. The FBI director received a subpoena to come to that proceeding. Yes, that and a subpoena is in order. Yeah, he was expected to comply with the subpoena. Well, that is the general expectation, and he didn't, right? And the result of that was that the committee's purposes were frustrated. Well, you could argue that, yeah, sure. Query: why not an obstruction of an official proceeding charge against Christopher Wray, director of the FBI? Well, it could be that he's housed within the Justice Department, and they typically don't sue their own. But wait, we've got Jack Smith, the hero of the day, the humorless Inspector Javert. You ever see a picture of Jack Smith? He looks like the kind of guy who could swallow his children's swing set and look impassively as they cried about it and not suffer indigestion. Why not create a special prosecutor to go up to take a look at what's going on with the FBI, confidential human sources, and consider bringing charges, not just for contempt of Congress, but for obstruction of an official proceeding against Chris Wray? Why not? Because it's politically inconvenient to do so. And it's politically convenient to target Donald Trump right now. And you can't help escape the whiff of the wick, the smell of the wick. You know, this is being overthought, manipulated, and that there are political decisions being made about who to prosecute and when. And that is the very danger of selective prosecution. And selective prosecution is possible in an era of over criminalization. What am I talking about? There's a wonderful book by a man named Harvey Silvergate, called 3 Felonies a Day. And I'm recommending that you go out and read it. It's a little dated now. He used to be a columnist for one of the Boston alternative papers. And he took a look at the federal penal code and he said, you know, there are so many federal crimes right now. Nobody even really knows how many there are. And you're like, well, how can that be? Aren't crimes statutory in nature? Can't you just go down and count them? Well, you can, but then you got to start mixing and matching the substantive offenses with the inchoate offenses. What? It's against the law to do X, to perform it yourself, but it also could be against the law to aid or abet or to conspire or to solicit or to otherwise involve yourself at the periphery of the event. And there are so many federal offenses that nobody knows how many there are. Now, at the time of the founding, there may have been a couple dozen felonies. And in an era of limited government, federal prosecutors had limited jurisdiction because there was only so much they could charge you with. I mean, early in the history of the Federal Bureau of Investigation, federal agents were killed in Kansas City, and there was no federal offense against killing, or no federal crime involving killing federal officers. So that was prosecuted on the state level. Congress amended the law to make it a federal offense, and thus there is one. Now there are so many federal offenses that federal prosecutors get a chance to surveil the world and pick and choose who to prosecute and when. And that was Silvergate's hypothesis, that each of us, in ways large and small, create at least 3 felonies a day. You can't help but do so because there are so many of them. And when you've obviously broken the law and prosecutors are overwhelmed with what to do, they get to choose who to prosecute and when, and for whatever reasons that they bring to bear in their prosecutorial decision. Is there any doubt in this case that Donald Trump is being targeted, not just because he's a lout, but because he's the leading Republican lout running for president? I'm not going to defend Donald Trump's conduct. If he played fast and loose with investigators, if he thought he was above the law, well, great. You get what you get what you give in this world, and maybe he's got a prosecution coming. But it seems to me that going after him for not returning classified documents with a special prosecutor in an era where we still don't have answers about Hillary Clinton's server, where there are millions of documents classified each day. We don't know who possesses them all. There's no adequate inventory of them. It seems to me that going after him on the cusp of the 2024 presidential election is a decision steeped in politics. And I don't know how it's going to play out in the electoral process. Nothing in federal law prohibits a person under federal indictment from running for office. Indeed, nothing in federal law prohibits a person in prison from running for federal office. Eugene Debs did so at the turn of the 20th century and got several million votes. I can't remember how much it was, but it was a large showing. There have been others who've attempted to run for federal office while either incarcerated or indicted. I don't know whether Donald Trump is going to be able to sidestep this or do a sort of jujitsu move that turns this energy against the government and makes him the penultimate or the ultimate now outsider, who has so shown his threat to the deep state that the deep state's seeking to put him into prison. I don't know if that will play among the broader electorate. I do know that the indictment surprised me. I'd predicted here a month ago that Donald Trump would be indicted in June. I thought he would be indicted in D.C., and I thought he'd be indicted in relation to the January 6th events. And I still think that's possible. I didn't realize, because I guess I wasn't paying attention. Mike and I do have day jobs that we attend to after podcasting in the morning. I didn't realize there was a second grand jury sitting in Miami. So when I initially saw this story last night, I thought, wait a minute. If Donald Trump is being indicted out of D.C. For events that took place in Miami, he's got a great Sixth Amendment defense, because there's something called the Vicinage Clause. In other words, vicinage, it being a rendering of vicinity. The Sixth Amendment says that you have a right to be tried for any alleged federal offense in the vicinity and state of the offense itself. In other words, in your home state where the event occurred, and in the right judicial district in your state. But it turns out I might have jumped the gun on that. If the indictment against Trump was returned in Miami, then it would be appropriate to try him in Miami. Now, query, where and when will this trial take place? Miami's federal courts are a rocket docket jurisdiction. They typically try to get their cases to trial, not within a matter of years, but within a matter of months. I don't know whether Trump will conceive of this as an opportunity to transform this trial into a campaign event. That would be worth seeing. Frankly, it'd be worth participating in. But I doubt a federal judge would permit him to do so. But if he wanted to hold up in display the prosecutorial decisions and their basis for them, he could try to do so in a Miami case. And this might be an ideal occasion to bring another challenge to the federal prohibition against jury nullification. Jury at the time of the founding, jurors had the right to decide not just the facts of the case, but also the law. In other words, when the United States of America brought a case against an individual, the juries just didn't. Its role wasn't confined simply to deciding whether the United States of America could prove its case beyond a reasonable doubt. In other words, it didn't just decide the facts of the case, it decided whether the law was properly applied. And Donald Trump's prosecution may present the best opportunity to preserve and pursue a claim that the right to jury nullification is a Ninth Amendment right, an inchoate right, a right that is reserved because it's not expressly prohibited by the United States Constitution. I would encourage Trump's legal team to hit this one hard, because they should be able to say to the jury, timing, do you think that this was serendipity for Joe Biden? Do you think in the very week that Chris Wray was thumbing his nose at Congress and refusing to provide documents about bribery as to Joe Biden, do you think it's any coincidence that that's the very week I got indicted? So stay tuned. It's going to be an explosive ride, I suspect.
Well, I think that's right. But Norm, I think we risk here getting a little too academic because what we know.
Me? A little too nerdy? Oh, wait.
Well, in terms of kind of burying the lead with respect to the, I guess, widespread intuition over this matter, right? Because you've hit that, and what I've put on the screen is Vivek Ramaswamy, obviously, but I've put also Elon Musk's tweet last night talking about the risk and loss of legitimacy, in effect, right? Loss of public trust in our institutions when there is the perception of a disparity or some sort of misapplication, or as Vivek says here, two tiers of justice. But I think one thing I can't really get away from right now is that the nature of the current administration seems very hostile to, I guess, an American archetype, right? One particular American archetype, and I don't know that this isn't something that is reminiscent of January 6th with respect to this persuasion to our baser selves, some sort of lust on behalf of the current administration and the current federal bureaucracy to urge those of a certain archetype, those of a certain loyalty, those of a certain courage and persuasion, and sense of civic duty to do something that they wouldn't ordinarily do, right?
I'm not sure I'm following you at all. Break that
So
down for me.
basically, is the federal government inciting the public to violence in an effort to pull that into the frame for exertion of top-down executive power in advance of the 2024 election?
Yeah, that's way too octane rich for my thin blood. I'm aware of
Well, the reason I say that though is because we've got, on the one hand, yes, perhaps that gets us where we're going a little too quickly. But on the other hand, what you're talking about with respect to judicial review through the courts, right? That takes years and years. And we're in a moment right now, right? We are about a year and a half from the next presidential election. And what's clear on this podcast, we've said from the beginning that there are going to be at least 4 indictments of former president and current presidential candidate Donald Trump before the election in November of 24. 2 of them have happened already, right? And we're talking about the second. The reason that this stream is titled Trump Indictment number 0002 is a reference to Jack Posobiec's saying that, the strategy is death by 1,000 cuts, right, for Trump. But it's also a reference to the fact that this is not the penultimate charge that Trump is going to be indicted for, the penultimate case, right? So we've got the Alvin Bragg stuff and the 31 counts of whatever falsification of business records from a state level Manhattan district attorney. Now we have the indictment for classified materials, which, by the way, Norm, is going to hinge on items that the public nor Trump nor his attorneys are going to be able to see.
Well, here's the workaround.
Disclosure of that stuff.
Here's the workaround. This is how I think a trial court manages it. Let's say there's a classified document about the size of, the North Korean president's dong or something. I mean, I don't know what Trump would want to keep that he would find of value, and to disclose that would suggest betraying the manner and means of U.S. collecting intelligence. In other words, how would we know how long was his dong? Somebody close to him must have been able to take a measurement or picture. So he's got the picture. The government learns he's got it. They ask for it back. He says, "Oh, no, I don't have it." Somebody else says they've seen a picture of that with the bearing top secret on it. Now, the best evidence of that is the document itself. And it could be that as to the retention of classified documents, the government chooses not to disclose its hand and thus deprives the finder of fact of relevant evidence, and therefore the charge has to be dismissed. However, the obstruction count, lying, conspiracy to obstruct justice, these counts could be raised without the admissibility of those documents. And so it may be that the government can't pursue everything it's charged, but I don't think there's a universe in which it won't be able to pursue anything. So that's my take on that.
Well, and then the other 2 charges obviously are more capstone charges. I mean, it won't be a surprise when the next shoe to drop, the next indictment handed down comes from the state of Georgia for federal election interference, right? And thereafter, Norm, something that you have actually talked about in the January 6th defense of one Proud Boy, Joseph Biggs, and his seditious conspiracy convictions, or on the way there too, I guess, was also that former President Trump should have been answerable, should have been subpoenaed, because the lion's share of that case rested on his encouragement of people to be at the Capitol that day. We don't have to agree that what occurred on January 6th rose to the level of seditious conspiracy on that part, but what would be the penultimate charge for Trump in advance of the federal 2024 presidential election would be a charge of at least seditious conspiracy in connection with the events of January 6, 2021 against former President Donald J. Trump.
No, I expect that to happen. In fact, that
is the crescendo. It is small, stupid charge first, fanfare, then it is this one. And the irony of this one, Norm, is that this one contemplates his entire first presidency. And his entire first presidency, this is my view, I haven't read this anywhere, but his entire first presidency was basically one large impeachment investigation.
Hmm.
It was investigation after investigation, accusation after accusation, phone call here, right? Uh, Mueller report there, Steele dossier this. We have the Obama campaign that has now been confirmed by the Durham report to have been involved in spying on Trump's incoming administration before he was sworn in, as far back as 2015. And now we're staring down a federal Department of Justice that can't be bothered to tell Christopher Wray to respond to the subpoena from Congress, as you already pointed out, but is perfectly willing to charge Trump with conspiracy and obstruction charges now in connection with documents pertaining to a presidency that was perhaps the most transparent presidency in history, against his own will because of the persistence of these impeachment investigations.
Well, yeah, I don't know. I hear you. I hear what you're saying. I've been puzzling over Freedom Lover's comment, and Freedom Lover, if you're still online, supplement it. Right, Norm? They all get punished for not following the rule of law. I'm not sure I understand that comment. I mean, the problem is there are the rule of law. There are rules. The law governs the moves that can be made on laws on life's board, but somebody gets to decide when those rules are broken and when to charge. And so we give to grand juries the right to, in the federal system, to conclude on presentation of the government's evidence whether there is probable cause to believe the law was broken. If they conclude there was, then an indictment is returned, and a criminal trial takes place where the government is given an opportunity to prove its case beyond a reasonable doubt. But we all know that the government picks who to charge and when, and that's the Silver Lake problem. And so, we don't all get punished for not following the rule of law. The rule of law is discretionary, and there is prosecutorial discretion, and that discretion is unreviewable. My point about jury nullification is there's got to be some way out of this box. There's got to be a way for the American people to reclaim a sense of efficacy in their own communities, of meaning and meaningfulness in their own lives, and they have to be elevated to serving as something other than chipmunks on the wheel of justice. Oh, you're only here to decide under the rules that I will tell you whether the government has met its burden of proof as to elements A, B, and C. When do people just get to stand up and say, seriously? This is how you're spending my tax dollars? The opportunity costs here of pursuing this prosecution are outweighed by the necessity of pursuing the other. And I would suggest that it is my view that I feel far more exercised, far more threatened, far more enraged by the FBI's use of confidential human sources in domestic surveillance and their refusal to provide information on that, lest we, the people, know their sources and methods. And I feel more outraged by Christopher Wray's thumbing his nose at Congress and rejecting meaningful congressional oversight than I do about Donald Trump.
Yeah, but Norm, I did not do a very good job, but that's what I was trying to get to earlier in the stream, is that we've already introduced this concept to our viewers of the nature of confidential human sources, and in particular respect to the January 6th Proud Boys seditious conspiracy trial. This was something that came to a boiling point for you as a practitioner in your experience and your history as a litigator and as an advocate. But
yeah, no, my pot hath boiled over. That's true.
Well, but this is what I'm fully expecting out of this indictment in the Mar-a-Lago classified documents case, is that the government is still not going to be able to point to a legitimate predicate. Which documents? Why? What? Because they're going to say, well, they're, national defense. This is a matter of national security, national defense. And Trump's legal team is not going to be able to get over that hump because of that same sense of forced opaqueness, right? That sensitivity of these things. So there is an alleged predicate to a crime, but we can't tell you what the predicate is.
Well, so let's talk about that. Let's talk about fundamentals. Let's talk about the Constitution again. The Sixth Amendment guarantees a defendant a speedy and public trial. Courts can elect to hold confidential hearings in the federal system on a nominal showing of necessity by the government, and they can hold secret proceedings during trial. I lost track of how many secret proceedings there were in the Proud Boys case. You know, the transcript just arrived in my office the other day of the trial. It's about 21,000 pages long, and there's a separate index of all the sealed proceedings. I think in the Trump case, his lawyers need to bear down and say, show that predicate, show that national security document so that the jury can decide for itself whether it's national security. I think a court is going to conclude that no, that would compromise national security, and that Trump's fair trial rights can be protected by having a witness testify that they reviewed him and it met certain criteria without describing how it met the criteria. In the alternative, in the communications that Trump's lawyers had with the government, those lawyers may have acknowledged, or Trump may acknowledge, he was in the possession of classified material. In that case, they may deem it may be deemed a matter of an admission by a party opponent, an admission by the party that the government is adverse to, which is an exception to the penal to the hearsay rule, and it may be that that's deemed an adequate foundation for admission of that fact that he was in possession of top secret documents. It could be that the case is tried without reference to them at all, except in passing, and to say that he lied about documents that he had returned. Again, there's a lot. I mean, we're retreading that wheel right now. We'll have to see the indictment, and then there are a lot of strategic considerations as to how that case gets tried. In the Cloud asks, why can't jury nullification be discussed as an option when giving instructions? In the Cloud, that is precisely the issue. Courts refuse to do so. The prohibition against jury nullification arises from an 1890s case called United States versus Sparf, S-P-A-R-F. Sparf was a maritime capital case. It used to happen that ships would sometimes leave one port with 10 people on and get to another with only 9. Where's the 10th, you say? He was killed. That's murder on the high seas, and that's a serious offense. The lawyers for one Sparf against in such a case said, look, we know the guy is missing and presumed dead, who I think it was the captain of the ship, but it could have been something less than murder. It could have been manslaughter. It could have been negligent homicide. Could have been a far less serious offense. That's what's called a lesser included offense. They took that appeal to the United States Supreme Court, and the court held that they weren't entitled to jury instructions on lesser included offenses because it is the court's role to decide the law, the jury's role to decide the facts, and there were no facts before the jury that would permit an inference that it was anything less than murder. That's all the court said. And so in that policy decision, in that it is the court's role to decide law, the jury to decide facts, the courts created out of thin air a prohibition against jury nullification, and it is prohibited in I think 47 of the 50 states as a matter of state law, and it is prohibited in 47 of 50 states and prohibited throughout the United States. And you can't get a jury instruction on that. I asked for one in a case called the United States versus Monsanto, and I got a trial judge who was willing to consider it in an outrageous set of facts involving the Commerce Clause. The United States government was so upset they asked for an emergency writ of mandamus and took me to the federal appellate court in New York City, and the federal appellate court slapped down the trial judge. He was so upset about it, he hired his own lawyer to vindicate his right to charge the law as he saw fit. And so, this is a ripe issue that I think needs to be preserved and litigated.
Norm, can you steel man the argument in favor of so many states having something like that on the books, just so that we can start from that baseline? What is the most charitable interpretation of not allowing jury nullification to be given to also be informed when giving jury instructions?
The civil rights cases in the 50s, 60s, and 70s, when persons of color were killed or lynched in southern states, and cases were brought against the lynchers, there were very, very often occasions in which the evidence that individuals had been involved in the unlawful death of another, where they were acquitted because jurors wouldn't follow the law. And so the argument was and is that the rule of law requires uniform application of the law, and it requires jurors not to decide whether the law was correctly applied, but whether the requirements of the charges had been met in the particular case that they decide, giving them the power, the right, the authority to say the government is wrong, could deprive whole classes of community of the law's protection, as was evidenced in the lynching cases. And
So-
it's an art.
Yeah, it's because it appears to me that maybe a simpler way to put that is that it is too big of an exception within the due process framework. It sort of reduces due process to sort of potential optionality in the hands of a jury from that perspective.
Yeah, well, that's another. I don't
Yeah,
know that the courts
that's-
ever really
yeah,
did it at that level of abstraction. But it's basically, you know, the fear that jurors won't do the right thing, and they won't do the right thing for the wrong reasons. In that case, because of racial animus. So what's Glenn Elmer's all wound up about?
I wanted to put this on the screen, and this is on the American Mind. I actually I listen to every single podcast that the guys from the American Mind produce. I think that they are an exceptional listen. And so if there's anybody that we're lucky enough to have that overlaps with the American Mind, would love to at least sometime maybe see if there could be some sort of Law and Legitimacy collaboration with them. But I wanted to put this in particular on the screen because we're talking about something, and I made the statement earlier that this is perhaps a situation where the federal government and the current administration is baiting large swaths of the American population, likely. And so when we talk about revolution, this article is great because what it does is it sets the stage for this conversation about what it means to revolt and what the American Constitution is. And Glenn actually goes through the four conditions that the framers or the signers of the Constitution believed needed to be met before a revolution could be justified, right?
Okay, so what I'd like to do, Mike, is I'd like you to review each one of them and give me a brief opportunity to comment on each one when you're done. So we do the first, let me comment, then do the second as seriatim. All right.
So the first is a serious infringement of natural rights. And that's why I said it was a moral position being taken here, because a serious infringement of natural rights is something much more serious than rights that we would say are conferred or recognized by document. So a serious infringement of natural rights is the first condition.
All right, so that begs the larger question of what is a natural right. When there was a broader consensus about the values that our communities upheld, we were able to not challenge the fundamentals of every decision. Men were men, women were women. Of course, it was wrong to groom a child. We didn't need to discuss that because everyone knew that. Jeremy Bentham, a utilitarian writer in England in the 19th century, once ruined the natural rights argument by calling it nonsense on stilts. That basically what natural rights are unstated and settled prejudices and perceptions that don't have to defend themselves. And so what he thought governed a society was a sense of utility. And so I would say that a serious infringement of natural rights is not a serious argument, unless you can seriously say there's such a thing as a natural right, in which case you have to anchor it in some broader philosophic or theological discussion. Given the lack of consensus, the lack of a foundation, of the lack of a commitment to a common conception of right, there is no foundation for natural rights right now. And the natural rights discussion becomes a matter of competing policy perspectives. We might have traditional Roman Catholics or Protestants who view the Bible as revealed religion and a source of God's law and natural rights. That's fine. But we also have in our community people who are radical expressive individualists, who mean that any expression of an individual's sense of their identity or self needs to be honored and respected. And then that the implicit natural right then is respect for all, which means tolerance of everything, which of course means chaos in our view. So I don't think you can mobile.
Right. The last paragraph here, I think, would be a counterweight to that, or perhaps is what puts it back on equal footing, in my opinion. But here, I'm just going to read it. It says, one grievance that's often forgotten, quote, he has excited domestic insurrections amongst us, end quote, is particularly important. Although peace and safety are not the final ends of government, they are the indispensable foundation of any healthy society and the first reason that people come together to form a social compact. Any regime that cannot supply the basic conditions of civil order is wholly illegitimate.
Well, fair enough. But then, in the context of revolt, presumably that's to turn out one set of people who can't and replace them with another set of people who can. It's an open question whether anybody can any longer, or whether we're simply just a failed state. So I'm not buying the first prong of his argument about revolution. I would suggest that there is a lack of legitimacy and social chaos obtains, but I'm not aware of a compelling theory of natural rights that I'm prepared to
natural
endorse.
rights, I guess, sort of the transgressing a system of natural rights ultimately is reduced back down to that last sentence, right? Which is ultimately, we don't have to have consensus on any one thing. We don't have to be, one religion or another, but we do have to have a regime that can supply the basic conditions of a civil order, right?
Well, I think we have one right now. When I leave, when we're done here today, if I choose to go to the store, I'm likely to survive the experience and charge a set of prices, and be charged a price that is the same price for all, as near as I can tell. Ride on roads where I'm not going to be shot at or driven off the road. Return to a home that's not occupied by others, and if it is, I'll be able to call authorities to oust them. So we do have basic conditions of civil order. That may not be the civil order that people want. That whole natural rights discussion, folks, this is a powerful, powerful, powerful argument. And, I, not that I'm making, but the argument against, for and against natural rights. In the early modern period, when Grotius and Pufendorf and others, Vattel, were writing books on the law of nations, they drew from a deep tradition, and they were able to say that there were things like right reason, that people reasoning correctly would reach the same conclusion about the source, nature, and content of our rights. And I remember taking a seminar when I was a graduate student at Columbia, and we were reading through Grotius, and I kept saying to the professor, "But what is right reason?" And because reason does reason set the ends in life, or is it merely instrumental? And if the ends are infinite, then so are the means. And reason in and of itself is incapable of providing rules that everyone agrees on, because, as David Hume, the 18th century Scottish philosopher, once put it, reason is and always has been and always shall be the slave of the passions. Let's talk about an extended persistent pattern.
Yeah, so an extended persistent pattern is sort of self-evident here. So if we're talking that the first is a serious infringement of natural rights, we're talking about that over and over and over again.
But what's the that? I mean, so right now we have a society that is deeply divided in visions, about what the good life is. We have the woke community and the DEI era that seeks, in the name of equality of condition, to level societies such that every flower blooms, right? And then we have others who claim that they have property rights, or others who claim that their vision of the good is inconsistent with DEI. I don't think things have broken down, that there's a extended, persistent period of chaos. I just don't see it.
It depends on who you are, I guess. I mean, we could just put Trump into the middle of this as the illustrative example about an extended, persistent pattern.
What's the extended persistent pattern? That he's a narcissist who can't get out of the mirror in the morning, and who
he's
believes
still a narcissist to what he would say is what? He would say, I received the most votes of any sitting president in history. So he's popular. Norm.
No, I get that he's popular, but what is the extended persistent pattern? What justifies revolution
We
right
spent
now?
the entire first part of this show talking about the threat of a dual system of justice, right? A two-tiered system of justice.
No, we didn't. That's Vivek Ramaswamy's rhetorical excess. What we talked about is prosecutorial discretion needing to be reined in, and we made a very earth-level suggestion about doing so by means of jury nullification, so that jurors could decide whether prosecutors were correctly acting in the name of the community. We haven't talked about a two-tiered system of justice where white people are treated one way and blacks another. That was a two-tiered system of justice. What we have right now is an imperfect and flawed system where prosecutors have too much discretion. We
All
should be
right.
talking about how to rein that
Well,
discretion in.
what about the stories that we cover all the time here, where we have school systems that are going to charge, I think this is yesterday, or the day before, school systems that are going to charge different dues for different demographics of their own teachers. What about I just had it in my head, but we go through this time and
That's
time
true.
again.
Well, it does create the risk.
You're the
It
premise of
does.
your entire joke about I need woke insurance, right? I'm a white man, et cetera, et cetera, et cetera. I feel like there is a foundation for an extended and persistent pattern, if that's the element that we're trying to get at here, of there being continued slights against the sovereignty, and these slights aren't just cosmetic. On balance and in cumulatively, right, it results in a massive dispossession of sovereignty as recognized under the Constitution.
I don't know about that. Those are bigger words than my small head can accommodate in this discussion. I do think that if we end up in a situation, that this is one of the reasons I'll be watching so carefully the Supreme Court's decision on affirmative action in both with respect to University of North Carolina and Harvard, expected any day now. And if the court concludes that based on identity, people can enjoy different statuses, different senses of entitlement in distribution of public goods and services, that would be a profoundly delegitimizing event, in my view, and could threaten to undermine the republic. I don't know that it deprives me of my sense of sovereignty, but it deprives me of my sense of equality before the law. And so that's a tipping point issue. The whole reparations discussion, in my view, is a discussion that takes us to the precipice of dissolution, because I cannot imagine a universe in which I will willfully decide to pay a surcharge based on my identity. I'm just not going to do it. That's a new form of slavery that I will not endure. A refusal to negotiate. What's with that?
Yep. So this is really easy to read, but I'll look at the second paragraph here. When these conditions have been met, i.e., persistent, serious violations of natural rights, along with indifference or even hostility to attempts at reconciliation, one could say that the bonds of citizenship have already dissolved, and in that sense, the social compact is no longer in force. How precisely a people should respond is a matter of practical judgment. But at this point, the right to resist has been established in theory. Still, there is one other essential matter to consider. And
So let's talk about the appeal to heaven, and let's talk about January 6th. And I know we're going over time, folks. Those of you who want more time, we're fulfilling your wish today. Those of you who don't, see it tomorrow, I hope, or next time. Um, the social compact theory suggests that government is a product of popular consent. And so the social contract theorists talked about folks living in a state of nature, not as an anthropological fact, but as a philosophical conceit necessary to advance the discussion. So we bargain with one another to obtain certain benefits by living in a society. In society is a Latin term, has its origins in a Latin term meaning friends. We strangers become friends to one another under the mediating influence of the rule of law. And we agree to be bound by those laws to protect interests of our own as individuals. That's the social compact theory. If the social arrangement that we find ourselves in frustrates our fundamental purposes, the reasons we entered into the contract can be deemed dissolved, and people retain the right to resist. This is as old as social contract theory, and it was much labored over during the English Civil Wars, and it led to the production of Hobbes's Leviathan, John Locke's Second Treatise of Government, Jean-Jacques Rousseau, Discourses on Inequality. But here's the problem, Mike. Who decides that the compacts failed? John Locke talked famously of the appeal to heaven. If you think the sovereign has frustrated your natural rights, you of course retain the right to resist, but you better win. Because if you don't win,
that's
you're
right.
going to get squashed. And that's precisely what's happening to
Right.
these guys in the J6 cases.
That's
The
right.
sovereign is burying its teeth and it's gobbling up these men whole. And so, you just don't get to wake up in the morning and say, it's Revolution Monday. Let's see what we can do for Tuesday. If you're in it, you got to win it.
The consequence of January 6th, though, beyond the individuals who will remain incarcerated for quite a long time, is that I guess Even the notion that one could be said to have conspired to commit sedition without any real concrete communications
Oh,
as
I got it. I
right?
got it.
That is that's the refusal to negotiate. It is the complete disallowance of association in a manner that has chilled people's ability to communicate in real space about these things. That was
I guess what I'm resisting, Mike, is the notion that we're anywhere near the right to revolt right now.
well, and
I
we're also
think
we haven't even talked about what the revolt would ultimately be, because and I want to be very clear. I'm not advocating for violent revolution, right? We are talking about the elements or the preconditions for what would be considered revolutionary acts. But the revolutionary acts could be localism. It could be start a family. It could be get married. It could be read the Bible. It could be whatever you want it to be. It could be self-sufficiency to the extent one can. And Norm, I think you would agree with that appeal to localism, with dissolving
Oh
one's
yeah, I'm all about that. When I look at Gavin
association with
Newsom,
society.
strutting around California, deciding what's good for the nation, I'm like, you know what? Let me succeed. I'm reading a fun book on succession right now about Vermont succeeding from the Union because, I have a place in Vermont, and I'm thinking, yeah, I'm down with that. I mean, I don't really want to be part of this menagerie of craziness. But I recall what happened the last time a few states decided to succeed. It was bloody and it was a mess. What's the fourth condition in Elmer's piece?
The necessity of a better alternative. Prudence is the word everyone invokes whenever discussing this topic, and rightly so, but it should be considered in light of what Jefferson refers to as necessity. The Declaration actually uses the word 3 times, when in the course of human events it becomes necessary. Such is now the necessity which constrains the colonists to act. We must therefore acquiesce in the necessity of separation.
Well, that's a
Hmm.
that's a topic that I mean, it makes me marvel because
Right?
when I think of the British separate when I think of the North American colonies separation from Britain, it was over so much less than what we endure in terms of our disagreements now. And so, the task of organizing government, the task of having rules and having ways of deciding how to apply those rules, guaranteeing rights for people who have those rules to solve or resolve their disputes in authoritative fashion. This is the work of centuries. And I'm not sure that just because I am so uncomfortable with what's happening in the world around me, that I have in my mind the means to devise a better world. Think about this. We've talked about this before. I'm
Yes, you
drawing a
do.
I'm
Yes, you
trying
do. Anyone
I'm
does.
I'm drawing a blank on the name of the author, but it Mary doggone it. I talked about her on the show before. She's written a series of fantastic books, and one of them questions in an essay whether social contract theory has outlived its usefulness. Because we always talk about John Locke's second treatise of government. We rarely talk about the first treatise. The first treatise was directed against a man named Robert Filmer for a book that he wrote called Patriarcha, which was a defense of James I's divine right of kings, the notion that all power flowed from God and therefore everyone owed the king absolute obedience. Filmer tried to dress that up in a philosophical anthropology. Locke took it apart. And in his counter to divine right of kings was a right of individuals to contract with one another in the manner we discussed thus far, and under natural law to create a better society. And it created all the concepts that Elmer's playing with here. But there is an argument that social contract theory is itself, much like natural law theory, nonsense on stilts. There never was a state of nature. I mean, let's do the chicken and the egg problem. Hillary Clinton, much though I hate to admit it, was right. It takes a village to raise a child. Individuals didn't spring fully formed from earth and didn't wander the jungles of the state of nature saying, gotta get a woman, gotta get a woman. What came first, the human or the community, the individual or the community? We don't really know. We know we need both. And it may be that social contracts theory's emphasis on individualism it has in part sowed the seeds for the chaos that we read right now, because when we all become our own philosophers and all decide what natural law means for us and all demand that we be recognized lest there be violence, what do you end up with? You
Is
end
this
up with the
Norm Pattis,
cacophony
the
of our time.
civil rights trial lawyer, or Norm Pattis, the CEO of BlackRock? that we're talking to.
This is
And
just Norm Pattis, a
right,
confused
but
guy
I'm just saying,
responding to Elmer's essay. And
right.
I'm thinking it's a little irresponsible to take a look at what's going on in the world right now and conclude that we're at the point of a revolutionary necessity when we can't even have a meaningful discussion about what natural rights are. Look, I remind everybody, I've been talking a lot about John Locke. Locke wrote 10 volumes of work that in a collected edition. The 1824 edition is the authoritative edition. 3 of those volumes are his discussion of how to arrive at a sense of what natural rights are. You can't have a serious discussion about natural rights without talking about their origins. And when they just become a placeholder, I don't like it, therefore you're violating my natural rights, you're every bit as guilty of the sort of anarchic nonsense that leads people to think that we need to show children transgender performances in order to develop their human potential. Natural rights is not a self-defining concept. And it may be that the rhetoric of natural rights and social contract theory is destructive.
I think, look, I agree with you. And I also am quick to want to ensure that what we're proposing, or perhaps your critique of the social contract theory, is not somehow misplaced or confused with what we're seeing manufactured in our society today. Because for consistency's sake, we have talked this week about what's going on in New York, with Mayor Adams talking about trying to encourage private individuals to house asylum-seeking migrants. And what I'm getting at is there is an entire momentum in a palpable shift in the American system, as it were. And so what that results in terms of a back-facing analysis of natural rights practically is that there is some sort of intellectual better, some collective of intellectual betters within society that have determined that people will have to be disabused of their ability to make stupid decisions, or decisions that don't inure to the economic benefit of the few who are providing for the infrastructure, right? Rather than, so it's okay that people aren't aware of the tenets of John Locke's treatises on natural rights, right? It's okay, but it's not. But it depends on who you ask as well, because if one were to ask Norm Pattis, your answer would be distinctly different directionally, but not so different in terms of what the words and the combination of words put together by someone who has a much more sinister vision of the future of the individual in America and in the world at large. I think that
Well, I do think, yeah, no, I do think we need to engage the discussion, and this has been very fruitful in my opinion. I don't know what our listeners think, and you know, I mean, and apologies to Glenn Elmers if I haven't given his opinions the weight they are due. I just think that waving the revolution word around, waving this around, is to walk another set of people into a potential slaughter against a sovereign they're not prepared to tangle with. Hey, let's end and let's continue this discussion maybe over the weekend, Mike. I mean, it's a good one. I saw Jason suggested a weekend thing, but let's end today with a discussion because I think it's apt.
Justin.
We what did I say?
Jason.
Yeah, Jason. Sorry, Justin. Sorry, and we've actually broken bread together almost. You know, I'm old. I'm feeble. You know, the hooks tying me to reality fray a little bit each day, and someday I'll just spin off out into the cosmos and maybe discover natural rights. Tucker on Twitter, episode number 2, Cling to Your Taboos. It's a long, rambling piece. It begins strong and ends strong, kind of fizzles in the middle when he tries to do too much. But basically, his position was to defend something like a natural rights point of view, that we have inchoate senses of what's right and what's wrong. His view is that we're born with them and we know what they are. Men are men, women are women. It's wrong to sexually abuse children. Cling to them and don't let people try to persuade otherwise. And from that joint sense of right will emerge a community in which the righteous will want to live. That's a quick 40-second rendition of what it took him 12 minutes to render. But he's useful in the discussion. And I think Tucker would think there is something like natural rights and that we know what they are. I'm not sure he's right, but I encourage all of you to listen. It's good to have him back in the conversation. We tried to induce him to get on last night
We did.
on Law and Legitimacy, and he said, I can't do that right now. So I don't know what his end game is with respect to his YouTube or his Twitter rants. I suspect he's trying to bait Fox into some sort of litigation, the likes of which we discussed yesterday. But welcome back, Tucker. Keep talking. People need to hear what you have to say.
That's absolutely right. Would love at some point in our small ecosystem here to have Tucker, come down from the clouds and land for a couple of moments with us. That would be excellent. I have a tremendous amount of respect for Tucker. I think part of what I was getting at last night with you on our text chain when we were talking about sort of the digital chapter in Machiavelli's The Prince, I was thinking through Elon Musk and his relevance to modern history. I think I may have even uttered the words that his acquisition of Twitter may be the most important thing of the third millennium.
You did, yeah. I want to hear more about that. Why?
Well, I don't know that I have to get to work at some point, Norm. But I'll say this because I'm still working through that in my head. It's not a new idea, but it is this version of what I would consider to be the American gods, and I don't say that in a manner that would.
Are you talking about Neil Gaiman's book?
Ultimately, there's an aspect to what I see in Elon Musk and his acquisition of energy and transportation, connectivity, right, and mobility, right, and to me, that is a combination that is a certain talent stack, but really manifests as a superpower. And without Elon Musk taking Twitter, there is no relief valve for Tucker Carlson when he inevitably is booted from Fox News. And Tucker Carlson on his own, he could run for president tomorrow and win. If Tucker Carlson in episode 3 of Tucker on Twitter, instead of doing a 12-minute talk about American taboo, decided that he was going to announce his candidacy for president of the United States in 2024, it would have only been made possible because someone like Elon Musk appeared in the timeline and appeared as a version of the prince and was able to conquer a hostile regime within the American government.
You're making my head explode today. When you uttered those words last night, what popped into my mind was a line from one of the Who's songs, "Same boss, new boss, same as the old boss." I mean, beware putting too much power in one person's hands, especially in the digitocracy, because this man who has just obtained FDA approval through Neuralink to engage in human augmentation studies with AI, and who is involved in so many other digital enterprises, will be at the forefront of whatever AI unleashes next. And I'm not sure that I am prepared to turn the world over to Elon. I want to manage it for myself in my own way, in my own time. And maybe that makes me a dinosaur.
Well, history is narrative based, and I love to think of history being a narrative. And there are heroes in history. And if there are any identifiable, I think that's the funniest comment.
All right, Justin, I screwed up. I'm old. I'm talking too much. I know Mike needs to get out of here.
Yeah,
so let's wrap it up. Yeah, let's wrap it up.
So right. I've really enjoyed this today. I didn't intend to take so much of your Friday, Norm, but I appreciate it nonetheless. And I know that everybody else in the chat here does as well. We've had a really strong presence of live viewers today and lots of engagement in the chat. So thank you to you all. Right now, we are focused on getting our Twitter profile to a goal of 2,000 followers. So for anyone within earshot, if you have a Twitter account, please consider following @Pattis Podcast. If you don't have a Twitter account, please consider making one and following @Pattis Podcast. All of our live broadcasts are also on Twitter as well. So it's not as if you couldn't just hit the notification bell and tune directly into this same stream. Whether you're on Rumble, YouTube, or Twitter, you can see this same stream live. What Twitter will allow us to do is engage with you in a more intimate way because we will have access to emails via the subscription model. And if we have access to your emails, we don't have to be subject to the platforms that we come to you on. We don't take it as a guarantee that they'll always be here or that our content will be something that is not suppressed or throttled. We want to make sure that as we continue to grow and build and mature as a platform and begin to expand what we're doing, that we do create some stability. So please, we're making an appeal to you. Consider following at Pattis Podcast. Help us reach that goal. And then other than that, Norm, if we want to get on one for this weekend, I think maybe Sunday is the best day for me. I've got family coming into town, but Sunday in the early afternoon might be a good one.
Maybe we should interview your dad on what it was like to, as a cop, to raise a young man like you. Let's talk later in the day about what to do this weekend. Stay tuned, folks. We'll talk to you soon.
Sounds good. All right, Norm, see you later.